Good morning. I'm Ward 1 Councilmember Brianne Nadeau, the Chair of the Committee on Public Works and Operations. Today is Wednesday, June 10th, 2026, and I'm calling to order this meeting of the Committee on Public Works and Operations to conduct a hearing on B26-0594 and B26-0621. The time is 10:09 a.m. Today we'll consider two bills that I just mentioned, the Contracting and Procurement Reform Amendment Act of 2026 and the Procurement Reform Amendment Act of 2026. The first bill on today's agenda is the Contracting and Procurement Reform Amendment Act of 2026. I introduced this bill with the support of Councilmember Louis George as co-introducer and Councilmember Parker as co-sponsor. My bill would expand upon and update the Procurement Practices Reform Act of 2010 to increase public transparency and streamline the contracting and procurement process. It would improve communication between the Office of Contracting and Procurement, other district agencies, and organizations that work with the district. The bill would require OCP to create a consolidated procurement portal that combines the district's multiple existing portals into a unified system, to develop plain language guidance and templates establishing standardized solicitations, to provide early notice of anticipated solicitations, and to enter into a data sharing agreement with the council. It would transfer the Office of the Ombudsman of Contracting and Procurement to the Office of the City Administrator and expand its responsibilities. In addition, this legislation would reform the district's supply schedule to enhance efficiency and fair competition, update requirements related to technical evaluation panels, and establish a permanent pay-for-performance program to promote improved outcomes and services for residents. Finally, the legislation would update council review procedures related to contract modifications and option years. The second bill on today's agenda is the Procurement Reform Amendment Act of 2026, introduced by Chairman Mendelson at the request of the mayor. This bill would amend the PPRA and related laws to revise and improve procurement and contracting procedures in the district. This bill authorizes delegation of certain powers by the Chief Procurement Officer, changes how contracts, modifications, and option years are reviewed and approved by the council, and clarifies procedures for supply schedule contracts, construction and transportation contracts, and capitally funded vehicle purchases. It would also revise procurement methods, increase the limit for certain non-competitive procurements of $25,000, and clarify the use of federal schedules and technical evaluation panels. The bill would authorize certified business entity set-asides for architectural and engineering services contracts and the use of retainage rates for certain construction contracts. Finally, the bill would revise subcontracting plan requirements and would update procedures related to suspension and debarment, contractor claims, and appeals before the Contract Appeals Board. I look forward to hearing from all of our public and government witnesses today. Some logistics for those joining us. In addition to being on Zoom, this hearing is being live broadcast at youtube.com/DC Council Public Works. All witnesses testifying on behalf of an organization will be given 5 minutes for testimony, and all other witnesses will be given 3 minutes. Let's see. We are about to start promoting witnesses to the first panel. If you're here in person, you may come sit at the witness table when I call your name. If you are on the Zoom, please accept an invitation to join the panel in just a moment. Okay, so our first panel includes Rachel Clark, Commissioner Paula Edwards, ANC 4A01, and Samuel Bonar, Policy Director of DC Community Wealth Builders. Okay. We'll begin with Commissioner Edwards when you're ready.
Good morning. Thank you so much for this opportunity to testify today. I am ANC Commissioner for Single Member District Paula Edwards, in Single Member District 4A01. I'm testifying today as an individual, but I'm using my experience as an ANC Commissioner and a CPA to inform my testimony. As a CPA, I've worked with government contracting at the federal, state, and local level, and this bill is very timely, and it's something that I'm glad that you're looking at now. The process of procurement is changing so quickly because of AI. And that's one thing that I think should be considered as you reform the process. One of the problems is I think there is specific legislation offered that is invariably going to change once the agencies start using AI more. There's going to be much less human intervention, much more machine to machine or system to system intervention. These systems are going to have to talk to each other with private systems versus public systems. There are many, many opportunities here for increased transparency, for increased output, for streamlining all kinds of processes, but there are many dangers. There's greater possibility of fraud detection, but there's also the greater possibility of fraud. So I really urge you to listen to the people in the industry who are navigating these changes right now. I reached out to the Association of NASPO, I'm sorry, the National Association of Procurement Professionals for their experiences. And they are looking at people who are at states and agencies that are navigating the process. Now, I'm kind of like Marley's ghost here because I did a system with IRS. IRS recently is trying to upgrade all its systems to AI. They put in an AI fix last year that kept us from filing timely. We got an extension, everything was fine. Then we got a notice from the same system this year that one of our clients owed $500,000 in fines. We called and they said, oh, the AI system sent that out. Don't worry about it, never mind. These systems have to be put in correctly, they have to be put in carefully, and this reform bill is going to force us to look at the way that we do things. I have written testimony that addresses the individual's issues, but I just wanted to bring that out right now. Thank you.
Thank you very much for, that shouldn't be happening. Yeah. Okay. Thank you very much for your testimony and for lending your time and your expertise to our discussion today, Commissioner. You mentioned AI is rapidly changing the procurement landscape. In your opinion, how should legislation be structured or altered to ensure it's taking AI into account?
And see, that's the difficulty because regulation always finds itself behind the curve.
Mm-hmm.
The changes are happening so quickly that regulation is struggling to keep up. But I believe you're going to have to be flexible enough to give the agencies the ability to work and to structure the implementations. It's really tricky. I would work with NASPO very closely with other states across the country because they're really establishing the ground rules and the best practices for doing this. But it's going to be a work in process. It's not going to be an easy task.
What specific fraud accountability or oversight should happen as it relates to AI in particular?
There is so much more ability to look across states, to look across contracts, to look across the industry, to pinpoint deviations using AI. That's one thing. The transparency, increased transparency is going to be critical. And you'll be able to spot a deviation. Usually, if you're using people, that could take months or years, but with AI, you could do it in a matter of hours. So I think there's going to be a lot of increased fraud detection, but you don't want to overburden the vendors by detecting fraud where none exists, like with my client's $500,000 fine. So it's going to be a tightrope, but it's so promising. I'm really excited about it.
Thanks. And have you, in your work, seen best practices from other jurisdictions that you would recommend?
I have seen some. They haven't really had time to work out, like with IRS's AI implementation. There are some things that are really good about it, but they've been put in so recently that we're still debugging it. So there's going to be a long practice of debugging. But the first thing is to do the implementation carefully, to test, to get feedback from the public as you implement it. You have to do a pilot project. What AI did was they just slammed it. I'm sorry, what IRS did was they just slammed it in, and then the public has to debug it. So you do need some kind of staging before you just go live for the general public. I really recommend that.
Great. Well, thank you so much for your testimony today.
Thank you.
Okay. All right, it looks like we have not been joined by any of our other public witnesses, so we will move on to our government witnesses. All right, so we will now be joined by Nancy Hateman, Chief Procurement Officer of the Office of Contracting and Procurement, and Robert Schildkraft, Chief Government Contracts, Office of the Attorney General. And I am going to administer an oath to both of you before you begin. So raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Great. Begin when you're ready.
Good morning, Chairperson Nadeau and members of the Committee on Public Works and Operations. I am Nancy Hateman, Chief Procurement Officer of the District of Columbia. I am testifying today on behalf of the Office of Contracting Procurement regarding the modernization of the district's procurement law by way of Bills B26-0621 Procurement Reform Amendment Act of 2026, also called the Mayor's Bill in the testimony, and B26-0594, the Contracting and Procurement Reform Amendment Act of 2026, which we will refer to in the testimony as the Council's Bill. OCP formally extends its gratitude to Councilmember Nadeau and her legislative team for their highly collaborative approach throughout this drafting process. We deeply appreciate your sustained eagerness to implement operational efficiencies that will significantly aid the district government's ability to procure faster and better while improving the experience for the diverse array of vendors looking to do business with the district. Both the Mayor's Bill and the Council's Bill were developed to support sound, equitable, and modern procurement practices. The current legislative session provides a profound and timely opportunity to introduce new procurement legislation that addresses the systemic bottlenecks that have emerged over the last 15 years. To provide a structured assessment of these concurrent proposals, my testimony is framed around 5 strategic categories. 1, faster approval, fewer delays, faster delivery. Mitigating statutory delays in the contract approval process is a top priority. OCP is incredibly pleased that both bills exist in agreement regarding the streamline of option period approvals. By ensuring that initial council approval covers subsequent unmodified option periods, we eliminate duplicative legislative reviews. To further reduce delays, OCP strongly supports the mayoral provision allowing contract submissions to be transmitted and counted during council recess. Suspending council reviews during routine legislative recesses creates artificial delays that severely disrupt services. Untethering essential procurement timelines from the recess calendar is an operational necessity. Both bills recognize the necessity of comprehensive annual program approvals to prevent staggered one-off delays, and we are in complete agreement on modernizing the DCSS, DC supply schedule. However, the Council's bill does not incorporate the annual plan language for capital-funded vehicle purchases as well as locally funded construction contracts. Rather than requiring individualized approvals for budgeted capital expenditures like ambulances, fire apparatus, and fleet vehicles, the annual plans would allow us to respond in a timely manner to manufacturer production windows and ensure the timely delivery of equipment so agencies can adequately execute their programs and provide high-quality services. We strongly urge the Council to incorporate the mayoral language grouping these approvals. Second category is stronger taxpayer safeguards. Protecting the district's financial and legal interests is paramount. We strongly support the mayor's bill's explicit prohibition of contract terms which are risky for the district. The mayor's bill addresses wording already present in vendor contracts, such as indemnification clauses that we must currently negotiate. The provisions in this bill would allow us to negotiate their removal, or if a vendor keeps the clauses, they explicitly become unenforceable. This streamlines both the negotiating time and the legal review process in awarding contracts. The council bill tackles taxpayer safeguards by establishing a permanent pay-for-performance program. OCP is not opposed to the overarching concept of expanding performance-based contracting. However, we have concerns with the statutory mandate automatically applying pay-for-performance provisions to sole source and multi-year contracts. Primarily, pay-for-performance provisions are not universally appropriate and should be evaluated based on the specific circumstances of each contract. Applying a blanket requirement could lead to confusion and increase the administrative burden on staff, who would then need to request internal waivers to address cases where pay performance does not make sense, such as software licensing or other situations where performance metrics cannot be accurately measured. Third category, more opportunities for local businesses. The mayor's bill includes impactful mechanisms to strengthen our local economy. We strongly support the mayoral provisions authorizing targeted set-asides for certified architectural and engineering services. This provides new avenues for CPEs and certified joint CPEs to compete as prime contractors for those services. We also welcome the flexibility to negotiate subcontracting plans with prime contractors prior to awarding them. Historically, following the precedent set by the Contract Appeals Board conduit decision, subcontracting plans were required to be fully finalized and submitted at the time of initial solicitation response. This standard eliminated the ability to negotiate and frequently resulted in the rejection of otherwise highly qualified bids and proposals. The proposed flexibility resolves the operational bottlenecks resulting from the conduit decision, allowing the district to work collaboratively with potential prime contractors during the negotiation phase to ensure compliant, enforceable, and robust subcontracting plans before a contract is finalized. Regarding the council's bill's proposal to transfer the Office of the Ombudsman for Contracting and Procurement to the Office of the City Administrator, OCP strongly recommends retaining this critical function within our agency. The Ombudsman's effectiveness is rooted in their comprehensive knowledge and understanding of procurement processes, which is cultivated by being housed within OCP. This proximity allows the Ombudsman to remain fully informed about the technical details and workflow of procurements, enabling them to respond quickly and accurately to challenges as they arise. Furthermore, the Ombudsman plays a vital role in OCP's vendor engagement efforts. Keeping this office within OCP ensures the Ombudsman has direct access to vendor outreach initiatives, training workshops, and community events. Because the Ombudsman is deeply familiar with the daily procurement lifecycle, they are uniquely equipped to educate the business community and address concerns promptly. Moving the Ombudsman to the Office of the City Administrator could reduce accessibility to procurement staff and local businesses, creating unnecessary administrative distance and limiting the Ombudsman's ability to leverage their expertise to support our shared goals. Next category is small purchases. Administrative burdens for low-dollar transactions are often vastly disproportionate to the value of the goods received. OCP unequivocally supports the mayoral proposal to raise the non-competitive small purchase threshold from $10,000 to $25,000. Increased costs and rising prices have impacted the purchasing power of this limit over the years. Elevating the threshold aligns with modern standards and reduces cycle times, allowing our procurement professionals to focus their expertise on high-value strategic contracts. And then the last category is addressing additional provisions. We must address several additional provisions where the council's bill includes mandates that conflict with established procurement standards and present potential operational risks to OCP. Technical evaluations, also known as TEPs. First, the statutory definition requiring a subject matter expert, SME, to come specifically from the procuring agency is not clear. For OCP, this has the exact opposite meaning. OCP is the procuring agency as we are the entity executing the procurement action. We believe the legislation intends to refer to the client agency or program agency. Even then, this restriction does not make sense operationally, as OCP frequently relies on interagency or independent experts when a client agency lacks internal technical specialists. Second, the bill does not reflect sound procurement practices. For example, the bill says that the procuring agency shall receive the full proposal package and any communications between OCP and the contractor related to the procurement, including pricing. However, when there is a TEP, the proposal package should go only to the members of TEP and not to the procuring agency in general to protect the integrity of the procurement process. Also, general procurement procedure practices require that the TEP should not consider pricing in the evaluation of the technical components of the proposal. At a minimum, the TEP should only be considering pricing after completion of the technical evaluation. Additionally, there may be communications between the contracting officer and the offerors that are not relevant to the evaluations of proposals, as well as the content of those communications cannot be considered as part of the evaluation in accordance with the solicitation's evaluation criteria. The bill also requires a contract review panel to receive written justification of a decision to reject the panel's recommendation at least 14 days before contract award, and that a SME, subject matter expert from the procuring agency, be included on the contract review panel. There are concerns with this provision as the inclusion of the SME on the contract review panel cannot substitute for the judgment of the TEP and the contracting officer, and the 14-day requirement may impact the timely award of contracts. Overall, this provision blurs the lines between OCP and the program agencies and erodes the authority of the contracting officer as set forth in current law and affirmed in Contract Appeals Board decisions. The procurement manual. The Council's bill requires a procurement procedures manual and defines it as the official guidebook to navigate the process. The designation of the Procurement Procedures Manual as the official guidebook creates uncertainty as to its legal status vis-a-vis the procurement statutes and regulations, which were created by official legal processes. The manual only exists to walk procurement professionals through technical and specific processes. It is not a means of regulation and does not supersede law or code. We are not comfortable with naming a procedures manual as an official guidebook for this reason. Cementing its status in statute restricts OCP's vital flexibility to dynamically adapt to evaluate evolving systems and processes. The data sharing agreement with the Council and forecasting module. To enhance legislative oversight, the Council's bill requires the CPO to enter into a data sharing agreement with the Council within 180 days of the passage of the proposed legislation. OCP unequivocally recognizes the Council's vital oversight role. However, data sharing agreements can introduce risks if sensitive data like procurement or financial data are involved. Procurement and financial systems are highly complex with numerous data points that can be interpreted in different ways. The data sharing agreement, as proposed in the Council bill, could lead to the unintentional misinterpretation of raw data. A direct data sharing agreement of this kind would require a significant amount of back-end technical infrastructure and expertise to host and maintain. Additionally, broad data sharing presents issues with maintaining the strict confidentiality required during active source selections before a contract is finalized. We feel that the Council bill as written is unclear on the breadth of the data agreement and what constitutes the other information required to be disclosed to ensure that highly sensitive pre-decisional evaluation data or proprietary vendor information is not inadvertently exposed. In place of a data sharing agreement, OCP highly recommends utilizing an improved transparency portal or open data portal that better serves a wider audience rather than investing time and resources into maintaining a redundant and burdensome portal specifically for this data sharing agreement. An enhanced transparency portal would allow for the secure and contextual presentation of procurement data, ensuring that sensitive information is protected and only shared in compliance with established protocols. By leveraging an improved transparency portal, OCP can provide real-time access to relevant data for legislative oversight, vendors, and the public, while minimizing the risk of misinterpretation or unauthorized exposure of confidential information. Further, an improved transparency portal would be designed using centric methodologies to incorporate user feedback and adapt to evolving needs, offering flexibility that a rigid, statutorily mandated data sharing agreement cannot. Ultimately, this solution supports both transparency and operational efficiency, aligning with OCP's commitment to safeguarding procurement integrity and enhancing stakeholder engagement. The Council's bill also proposes updating the forecast module. While OCP supports the intent of enhancing transparency, the specific mandates present operational challenges. Annual procurement planning looks 12 months into the future. Specific subcontracting and CBE requirements would not be known at the time of forecasting because the exact dollar values and market research for the specific procurement are not yet finalized. Furthermore, mandating the publication of a client agency point of contact contradicts procurement communication protocols, subverts the statutory authority of the contracting officer, and invites increased vendor lobbying. The Consolidated Procurement Portal. The Council's bill mandates the creation of a centralized portal that facilitates communication between OCP and its client agencies while increasing public transparency and streamlining the contracting and procurement process. While completely revamping our portals and how we interact with internal and external customers is already on OCP's technology roadmap, codifying this in a bill potentially limits our scope and dictates premature priorities. OCP's priority is to improve the external customer experience first. Mandating this portal now may force OCP to focus on an internal portal before our upcoming modernization of PASS, leading to highly redundant back-end work to ensure the portal functions with both our legacy PASS system and the new Oracle system. We strongly recommend that the legislation outline overarching goals and objectives rather than defining rigid technical requirements, such as specific access licensing and granular tracking systems. Defining strict technical requirements in legislation commonly causes significant issues with deployment and system configuration. It reduces our technical team's ability to utilize user research and surveys to develop agile solutions that meet customer needs, often resulting in systems configured with good intentions that fail in practice. OCP has a number of technical amendments to the provisions of the Council's bill. These include technical amendments to the transparency modules, such as system integration, independent agency data management, and forecasting module estimates, but are not limited to just those areas. We ask to discuss these technical amendments directly with your staff to ensure efficient implementation. In conclusion, the 2026 procurement reform effort represents a watershed moment for the District of Columbia. By adopting the streamlined administrative pathways of the Mayor's bill, while carefully refining the transparency, forecasting, and evaluation panel provisions of the Council's bill, we can forge a procurement framework that is faster, fairer, and unequivocally focused on delivering maximum value to the taxpayer. Thank you for the opportunity to testify today. I welcome any questions the Council may have.
Good morning, Chairperson Nadeau, committee staff, and residents of the district. My name is Robert Schulkraut, and I am Chief of the Government Contract Section at the Office of the Attorney General for the District of Columbia. I am here today to testify on behalf of OAG on Bill 26-0594, the Contracting and Procurement Reform Amendment Act of 2026, and Bill 26-0621, the Procurement Reform Amendment Act of 2026. Both bills propose revisions to the District's Procurement Practices Reform Act, otherwise known as the PPRA, the law which governs the procurement process for the District of Columbia. The PPRA provides the foundational structure for district government procurement and is integral to the work that OAG Government Contract Section does. As part of our duties of the Government Contract Section, we review for legal sufficiency proposed contract action subject to council approval, advise the Chief Procurement Officer and agency contracting officers on procurement-related matters, and defend the district in procurement disputes before the Contract Appeals Board and Superior Court. It is therefore in our interest to strengthen the framework of the procurement process. For that reason, we are encouraged by both proposals in both bills that work towards this goal. In particular, we appreciate the effort to strengthen transparency, promote more fair and equitable treatment of vendors, and enhance competition in district procurement. Below, I will highlight the elements from each bill that we support. I also offer several recommendations to further strengthen the district procurement process, which we hope the council will consider. To begin, good procurement policy enables a district to acquire needed goods, services, and construction in a manner that provides the best value to district residents. My testimony focuses on three important goals: transparency, fair and equitable treatment, and finally, competition. Greater transparency allows for identifying and correcting inefficiencies in the procurement process, enabling greater input from program agencies and the council, and most importantly, enhancing public trust. Prioritizing fair and equitable treatment creates a consistent and stable playing field while encouraging greater participation. Encouraging competition fosters a robust procurement process and helps the district obtain best value. Now, these goals are complementary and mutually reinforcing. Together, they provide the framework for a strong procurement program, and any revisions to the PPRA should assist the district in meeting them. At the same time, it is important to not only enhance transparency through greater communications between the contracting officer and council or program agencies, but to also maintain integrity, to maintain and enhance integrity in their procurement process. And full and open competition must be balanced with competing policy goals like the Small and Certified Business Program. We hope that this committee will integrate our recommendations into whichever bill it chooses to mark up. OAG supports both bills' goals of making the procurement process more transparent to the public, vendors, and to the agency. The proposal in B26-0594 to establish an Office of Ombudsman for Contracting and Procurement within the Office of the City Administrator would help contractors and district agencies communicate complaints and concerns about contracting, procurement, and specific contracts, furthering this goal. OAG would like to discuss with the committee further, however, the ombudsman's role as it relates to agencies with independent procurement authority. Separately, B26-0621 recommends clarifying the standard of review for appeals of debarments and suspensions. While the Contract Appeals Board has exclusive jurisdictions over protests of solicitations and proposed awards and appeals of contract claims, it also has exclusive jurisdiction over appeals of debarments and suspensions. However, the current statutory language may be read to conflate appeals of debarments and suspensions with appeals of contract claims, creating ambiguity as to the appropriate standard of review. Clearly articulating the appropriate standard of review for debarments and suspensions removes this ambiguity and increases transparency by ensuring that vendors understand their rights under the law and that all vendors are treated fairly. Although not currently in either bill, the district could also increase transparency in the procurement process by providing enhanced debriefings to vendors after an award to help them understand how the proposals were evaluated and why they might have been unsuccessful. B26-0594 includes several provisions to increase transparency in the procurement process, such as allowing certain information to be shared with the council and or the client agency. While OAG appreciates the need for clear lines of communication, it remains important that the contracting officer maintain control of the source selection decision and avoid the appearance of outside influences on the decision-making process. In addition, OIG supports both bills' goals of making the procurement process more equitable so that vendors that have not previously participated in the district's procurement process will be more likely to participate in the future. Requiring every solicitation to state in plain language the purpose, objectives, evaluation factors, and performance measures promotes clear, consistent, and measurable criteria, helping to ensure fair treatment among offerers and potential offerers. The Office of Contracting and Procurement has already developed and maintains a suite of standard templates to assist contracting officers in administrating the solicitation and contract process. B26-0594 recommends enhancements to these processes to further standardize district procurements. An established procurement process that provides advance notice of requirements and creates uniform procedures across district procurements would enhance public trust and encourage more vendors to participate. Finally, B26-0621's goal of codifying current district practice and providing clear notice to all vendors about certain prohibited terms and conditions in contracts under district law is good policy. Explicitly identifying these prohibitions in statute would prevent vendors from being surprised by these restrictions. These policies create a consistent and stable system for vendors to operate under. Also, it is well understood by those in the procurement, in the public procurement community that competition often leads to better value for the government and rewards suppliers offering new and improved products, technologies, and approaches. There is language in B26-0621 designed to let contracting officers request corrections to subcontracting plans with errors. If approved, this will increase competition. Under the current statute, too many offerers with faulty subcontracting plans that include even minor errors are excluded from the competition. This would potentially allow these vendors to remain in the competition by correcting the errors during the procurement's best and final offer process. This change would also help the district obtain better value, as lower priced offerers are often excluded solely because they submit a defective subcontracting plan. Although not included in either bill, we also recommend enhancements to the sole source contract award process and the cooperative purchase agreement award process to allow more vendors to compete for district business. Making it a requirement that cooperative purchase agreements being used by a district was previously competed by the leading jurisdiction or entity would assist with achieving this goal. So too when engaging procurement agencies early in the procurement process to make sure sole source decisions are not based upon lack of planning. In sum, OIG is grateful to the chairperson Nadeau and the committee for considering this important issue. There are additional recommendations that we would be happy to discuss with the committee that would further strengthen the district procurement process and enhance transparency, fairness, and equal treatment and competition in district procurements. Thank you, and I welcome any questions.
Thank you both for your testimony. Let's begin with B26-0594, the Contracting and Procurement Reform Amendment of 2026. Most of these questions will be for whoever wishes to answer them, so you can feel free to jump in, but I'll specify if not. Regarding the proposed change to council review of contract modifications, can you talk a bit about the intent of this section and clarify how language changes current practices?
Okay, I'll kick this one off and then Rob can add if he has anything. So this is really for review of contracts where, for example, the action initially was not over $1 million. And we OCP did an action such as exercise partial option, which was under $1 million, which was a legal action at the time. But then when we exercise, for example, the remainder of the option period, it takes the total amount over $1 million. Right now, the council treats that as what we call a tipping package. The council calls it a retroactive approval. And what that means is it lengthens and complicates the approval process because it now must be done by legislation, heard at a council session and approved by affirmative vote. So this language is proposing that situations of that kind could receive passive approval because there were no improper actions or anything like that involved in it, and that the passive approval would be the regular 10-day council approval process. So the intent is to streamline the process for those types of packages.
The language, oh, did you want to jump in?
Was your question regarding whether or not option packages are going to be reviewed by council if there are no material changes? Is that what your question was?
Yeah, basically. I mean, how the language would change the current process. So,
Right, well, OAG only reviews option packages if there is material change to them. So if there's no material change, it won't necessarily change our role in the process. However, the council could find themselves potentially approving option periods that the contracting officer never actually approves later on. There is a chance that the council could end up approving option periods at a time when the funding hasn't been approved at that period of the process. It's also a possibility that option periods could be approved when the pricing hasn't been finalized due to certain contracts that require enrollment based upon other certain formulas that determine pricing at a later date. But otherwise, it wouldn't change the process very much.
So if I can come back to my response, because I thought you were asking about the one for the tipping packages. So it seems like we are discussing options. So I want to say the idea on that is that for the options, basically, we're doing a lot of reviews and paperwork to approve provisions that were already in the contract, and there are no material changes to them. And I think that that is a sound practice. It's also consistent with the general interpretation, what is a contract and what does it include. And so the council will be getting the whole package, including the pricing for the option periods in it. So the information would be known at the time the package comes to the council. Now, Mr. Shilkar did mention that sometimes there's not funding. Well, there would be no funding for the option years, but no option period would be exercised without the funding from the Office of the CPO. So it doesn't change that in that respect when we would fund the action, and it would have to be funded before it's exercised.
I may have caused some confusion. So we now answered a question that I meant to ask, but not this minute. So I won't ask that one, but this one, as you thought, was related to modifications. So I don't know if, I think your answer would stand for that.
Yeah, my
And then-
answer is fine. for
Okay,
that.
and then would you have anything you wanted to add on contract modifications?
No, that policy makes good sense as
Okay.
far as not necessarily having to do legislation for every single one of the active packages that we have. And we call them tipping. They're not true retro packages in the way that something was incorrectly done.
Understood. Okay. And the language just doesn't distinguish between proposed contracts in excess of $1 million that are subject to passive review and those subject to active review. Is that intentional?
Yeah, that was intentional.
Okay. And how would this change impact contracts subject to passive review versus those subject to active review?
Okay, I think I addressed some of that
Okay.
already in that we would eliminate the need for a bill or proposed legislation to be introduced to approve the contract. The council would no longer have to vote on it at a council legislative session, and then it would not have to get the signature of the mayor. So it
Okay.
would streamline the process.
Okay, all right. Okay, I think we answered that. All right. So regarding changes to option years, we've learned that this would effectively classify a base plus option year as a multi-year contract, which requires active council approval. Are you aware of that?
I don't agree with that interpretation because a contract remains a base with options. A multi-year contract is where you have a contract with a base period that encompasses more than a year. It might be 2, 3, or 4 years. So the approval does not change the underlying contract at all.
Okay.
I understand Mrs. Hateman's opinion we've discussed it internally, and we're not clear that's the case. The approval will be for the, you would be approving for, usually for a base period and all 4 options. That would be a 5-year period that is being approved. We would potentially consider that to be a multi-year procurement.
That does not change, the underlying council package or contract package does not change to multi-year. And I would like to point out there was a period of time where the council did approve contracts and the option periods, and they were never treated as multi-year contracts.
Okay. Well, how does the requirement of legislation for multi-year contracts impact the intended outcome of the provision?
I think it would actually limit the benefit of that provision because, as you know, multi-year contracts funded with annual funds have to be voted on at a legislative session and have to be affirmatively approved. There's no deemed denial of a multi-year package. In addition to that, because of the council recess situation, we normally have to submit multi-year packages by the last session before the summer recess. And then because of the schedules, they often don't go on the agenda again until October, which is a long period of time that we would be unable to get approvals of anything requiring affirmative approval.
Okay. Okay. Can you talk about how the proposed changes to the review of contracts for the DC supply schedule would differ from current practice?
Yeah, right now what we do is we send each DC supply schedule contract to the council for review and approval. We have 16 categories for DC supply schedules, and then within that we have multiple contractors. So I anticipate that we have probably close to 400 existing contracts for DC supply schedule. Some of them have ceilings that are over $1 million, some don't. What this would do would allow us, for example, for things that we know are coming up in that year, pending applications, option exercises, that we could indicate in a plan to the contract what actions are coming up versus having to submit the individual packages. And we think this is beneficial because the terms of each contract are basically the same. The only thing that really varies is the pricing. The contracts within each supply schedule category are uniform.
I am familiar with the plans of contract. I'm not sure I've actually ever seen what it looks like. I think it's just a list of contracts. We do have them for the Federal Highway Administration. I believe they are a subset that do not fall under the district's Home Rule Act. So there's a special carve out for them. I think the DC supply schedule contract would still fall under the Home Rule Act. So there is a requirement for council to review them. I'm not sure whether the review of the plan of the contracts would satisfy that or not. In any case, it certainly would be more efficient. And efficiency is important, but it's important to balance that efficiency with the 3 goals that OAG have, which are transparency, fairness, and competition. We do review these DC supply schedule contracts in collaboration with OCP, and we believe we add a lot of value in those reviews. We check to make sure the vendors are responsible. We check to make sure that all compliance documents are in order. They are more standard in many ways, but we have received bid protests on DC supply schedule contracts. So we look out for those to make sure that we catch any potential, any risks that could lead to litigation. So we believe we add value, and it's unclear if we would still be involved in the process if that were to occur.
I want to just talk about the home rule aspect. The annual plan for transportation contracts is in the Home Rule Act. I'm not saying the Home Rule Act would not apply to them. I'm saying that the Home Rule Act also allows for the council to set the review process and standards that it wants. And so I think that that language has flexibility to allow the council to say what they want to see and how they want to see it.
Okay. How often does OAG identify issues that require corrections during its contract review process?
I don't have an exact number on that. It's my belief that the process works best when we're collaborating with OCP or whichever procuring agency that we're working with on each contract action that we get. When we get the contract action, we will go over to make sure that, again, we have all compliance documents, that we have a proper price, that the vendor is responsible, that if we have a new award, we have a good source selection basis for that award, that we're using the correct contract. If the contract's being modified, we want to make sure that that modification is within scope of the original contract. We go through all these things with and collaborate with our client agency to make sure that everything is in good shape. And we think that's the best way to continue.
And do you have any concerns about provisions in this legislation that would remove OAG from the process in places specifically where you've seen issues come up before?
Well, just in some of the contracts that are being suggested to be placed in the plan of contracts. We do review a lot of those contracts, and it's unclear to me what our role would be moving forward in that.
Okay. And from the perspective of OAG, what measures could be implemented to reduce the likelihood of contracts being submitted with errors?
I would keep us involved in the process. I think we work very well with our the OCP. We have an excellent relationship with them and our other procuring agencies. And we have expertise, we're unbiased, and we look for potential procurement pitfalls that could lead to protests, which would slow down the process a lot more than our involvement in the review.
And how do you feel that collaboration helps prevent errors, Dr.?
I think that there is great benefit to OAG participating. I think it's a question to defining where the best benefit is. For example, when we do solicitations for over $1 million, we want to send them to OAG for review prior to their issuance, because that really sets the stage for having a procurement that is a proper procurement. We do appreciate also their defense of the procurement actions under protest. So I think that's an important function of what they do. In terms of the council, of the reviews of other contracts, they do provide value. I think sometimes we need to talk about the timeliness in which we can get the assistance and sometimes there are legitimate differences. And so we shouldn't confuse the idea of having legitimate differences to the fact that there may be, they don't equate to errors in the package.
Do either of you think we should be looking more closely at statutory requirements of the information that's required in council submissions?
I think there's some parts of it that maybe aren't needed. When you look at it right now, we have 5 different templates with different information, some overlapping and some different information for sole source, competitive, letter contract, emergency, retroactive. So I think there is some, if there could be efforts to reduce the information or maybe make them more combined, that would be beneficial. There's a couple of provisions I really don't think probably add a lot of value for the council review, and I'd be happy to discuss those, like I said, with your staff.
Yeah, OAG has something to add to that. It's really, we think it's up to your discretion what you think you need for your review.
Okay. All right, moving to the Office of the Ombudsman. How would OCP improve the effectiveness of the Ombudsman's office as it currently exists?
In terms of the Ombudsman's office, we think that there is a great effectiveness with them now. We do have vendors or potential contractors reaching out to the ombudsman. But one other thing that we do with that office that I think is very valuable is having the ombudsman participate in vendor outreach events, whether they're OCP's events or whether they're events that other entities sponsor, like HBX, there's government procurement conference coming up or event coming up. We do those through the year. And the thing that's important is that the ombudsman is developing connections with the business community, the vendor community, so that they have confidence in the ombudsman, and the ombudsman can just work in assessing what information those vendors have provided. Some of them give feedback on specific situations. Some of them give feedback on things we could do to improve our website, our transparency portals. So we get a variety of feedback. And I think for us, just continuing those efforts to connect the ombudsman to the vendor community gives us great insight into what issues are out there in the vendor community.
Okay. And do you have any concerns about an oversight office being housed under the agency it's supposed to oversee?
I'm sorry, could you repeat that, please?
Do you have any concerns about an oversight office being housed under the agency it's supposed to oversee?
Well, I think there's always a question about that, but I think that for us, the important thing is that when a vendor or a contractor contacts the ombudsman, that they can get the expertise and the attention that they need very quickly. I think when we talk about moving the ombudsman to another agency, we've added another layer, another step to it, where they might go to the other agency first, which houses the ombudsman, and then that gets translated down to the agency, and we would still have to address the situation. So I think the directness of the communication is important.
OAG doesn't have any real opinion on where such an office should be located, other than it should not be located at OAG, because what the ombudsman does and what OAG does not align. We really are more for defending our agencies. And a lot of times that even includes litigation, which might be in conflict with the vendor's concerns. But we think, strengthening the ombudsman's office is a great idea. It adds transparency and it gives a place for vendors and I guess even agencies to go when they have questions with the procurement that are not appropriate for the OAG's office.
Okay. I think we'll move on from that for now. To pay for performance. Director, you said you support more pay for performance contracts. Why aren't there more of them now? Is there anything in the PPRA that makes them more challenging?
No, there is not. I think it's a question of also getting people, including the program agencies, to think about what the metrics might be for what you are willing, what the deliverables or deadlines should be for assessing performance. We use them already in areas, mainly in human services, and they have contracts for the TANF program that are for job training and job readiness, and those contracts set forth the various parameters and what has to happen by that certain date, and then what the impact is on the payment. I think they're very successful, and I think there are other types of services and goods that they would work for as well.
Okay. I don't know if you have anything to add to that, Mr. Schildkraut.
No, I think Ms. Hateman hit on the key points. Sometimes the metrics are hard to determine for these types of contracts, but she's right. They've been successful in many cases, and I'm not sure they should be statutory for sole source contracts and similar, but they should be used.
I think one of the challenges as a metrics that people struggle with sometimes is you have to think about what behavior you're really rewarding when you put a certain metric in a contract.
Yeah, agreed, absolutely.
So what do you think are the best types of procurements for that model?
Well, I think I've used the example, I know I've used the example of the TANF contracts many times, but I think they are an example where you have an ability to, in those cases, the contractors have to train or have people attend certain job readiness sessions. And so you can have the sessions and you can assess whether people have successfully completed. They don't get paid for just having people show up. For example, they get paid for showing that they have engaged in behaviors that move on to the next step. So I think a lot of programs on training and a lot of social service programs do have that ability to look at more what are we really rewarding the contractors for.
Interesting. Yeah. I mean, I guess there's sort of a fundamental question with pay for performance. Are you paying them to do the thing? Or are you paying them to achieve a certain outcome?
Yeah, and it's really the focus on the outcome that should be the basis of the performance. So sometimes performance metrics are focused more on just paying for something, let's say send someone to training, but you don't want them to just go to the training. You want to see that you've provided the ability for them to be able to have a job placement for
Yeah.
a certain period of time. And I guess I also want to say, these can be useful in construction too. And I know I talk a lot about the social services, but for example, in construction, and we have used them on occasion, where incentive, if the contractor finishes the project X weeks before before the date in the contract, they get a certain incentive. If they
Right.
finish it a different period of time, they get a different incentive. So it's not just the social services, but I think there is a lot of room for them to be used in the social services area.
Yeah, although I would hesitate to say that the social services are the best place for our government to expand in the same way as you explained with construction, because I think we're often underfunding those services one way or another. And thus a perfectly good partner could be undercut by that, as opposed to a contractor who's building something where it's pretty straightforward. You're not dealing with humans in the same way. I almost feel like a pay for success with human or social services would work better if we had also a philanthropic partner who's, helping fund things.
Yeah, I wouldn't
robustly.
take the construction model and impose it in
Yeah.
the social services arena.
Yeah.
But I think there are different ways that there can be pay for performance depending on what's being procured.
Noted.
Yeah, nothing to add. Ms. Heyman put that very succinctly. I've seen in the construction,
Yeah.
but I haven't seen it much elsewhere.
We have like one of those right now for streetlights through the P3 office, if I recall.
We have the
correctly.
P3 contract. I'm not familiar with the details of
Yeah.
it, but we do have that for streetlights.
What else does the P3 office do?
I personally am not aware of other current projects at the moment because they don't really, that goes through, I think, the Deputy Mayor for Economic Development.
Yeah, or maybe the city administrator even. Okay. And are you familiar with the structure of that particular contract?
For the streetlights, no.
Yeah, okay. It's kind of strange that it's such a basic contract in the end, but it's happening sort of outside of your realm. It's a little weird.
Well, it is, but I think that what I do know about it is that because of the way the financing of the project was done, there were complex financing and multiple entities participating in the contractors' arenas. So, for example, there were people guiding the district, but then the contractor themselves have to get their own financial support and all that. So
would it make sense for that to be happening under OCP generally?
it could go either way.
Okay.
I do believe in streetlights, we had a staff member that was supporting that initiative, but it was not an OCP project.
Was OAG involved, do you know, with the streetlight P3?
Yeah, that we did see that contract when it came through. It was a while. I don't remember the specifics.
It was
any
like
longer.
many years ago, but I
I was here, and I remember
Yeah.
it came through our office. We had one of our attorneys working in depth on that contract, actually. And there was a lot of excitement at the time for the P3s. We thought it would be a new innovative way to do contracting, and
And then
it
that
seems to
was
have
it.
stalled out. Yeah.
Yeah, I agree. That was like, yeah.
It's complex, and because you're looking at funding from other sources, whether they issue bonds or they're funded by revenue, it's got to have a particular type of project that it works where they really feel that the funding source will be sustained to guarantee the payment to the contractor.
Right, makes sense.
Yeah.
Yeah, I don't think we've done one since.
No, I don't think so either. And also, I'm not sure. I mean, I'm honestly not sure of the impact it's had on streetlights generally. I mean, I guess I'll have to put my ward member hat on and think about whether I've had fewer complaints since the contract went into place. But it sounded like it had a lot of bells and whistles that I don't know that we've been read into in terms of how they're being implemented. So maybe that's something I'll look into in the next couple months, just to see how it's going. Okay. Hold on, I got to figure out where we were because I really went off on a tangent for that one. Okay. For pay for performance, are there specific revisions you would recommend to ensure alignment with OCP's existing processes and practices?
I can't say at this point we know enough about the proposed legislation to give you any specifics on that.
Okay.
On the pay for performance, I think, and OAG referenced this, is I think my only concern is that it mandates pay for performance for sole source and
source, yeah.
multi-year.
Oh, yeah.
Otherwise, I think regular procurement processes can work for pay for performance.
Okay.
Sure, thanks for explaining. Yeah, I think it's probably may not work for all sole source procurements for various reasons.
Okay. The DCMR references incentive-based contracts. Is that effectively the same as pay for performance?
They can be a tool to be used for pay for performance. So yes.
Does it include inclusive of other things as well, or?
No, it's probably, and yeah, it essentially is pay for performance. But there's different ways that you can pay for performance. And if you look at the provisions in the regulations, some of them are more along the lines of what I described in the construction area. Some of them have adjustments for basically cost control, and then they get paid for that. So there's variations of it, but the concept all really probably supports pay for performance.
Okay, I think we can move on from that. All right, looking at technical evaluation panels, could you please describe the role of technical evaluation panels and explain the process for selecting panel members?
Okay, for the technical evaluation proposal panel, they are used in procurements by competitive seal proposals, which are done by a request for proposal or RFP. The role of the panel is to review the proposal submitted, evaluate it, and in our case, after the panel does individual evaluations, they do a consensus evaluation where they come together and determine as a group what they noticed and what they think the rating should be. After that, the recommendation from the TEP goes to the contracting officer, and it is a recommendation, who then reviews the TEP results against the criteria in the solicitation and determine if there's questions, if the panel seemed to miss something, if they misinterpreted a provision. And then the information from the panel is used along with the contracting officer's review to determine how to negotiate the contract, because generally in an RFP, you don't get a proposal where you can just make an award right away. So that information from the TEP provides a lot of guidance as to the areas that we need to have for our negotiations with the vendors. And then after that, the contracting officer will request what is called a best and final offer from the vendors. And then when those are obtained, those go back to the TEP as well to see, here's additional information. Does this change your impression of the recommendations that you made previously? And as to the appointment of them, our contracting officers talk to the program agency. Usually it's to the person that the panel has already, that the agency has already identified as the program manager, and we will get recommendations from the agency. If the agency cannot identify people within the agency that they think are appropriate for a full panel, we will look to see if there's people that they know of other agencies or other independent groups to be on the panel, as long as there's no conflict of interest.
Okay. So we've heard that panels receive different bid materials depending on the contracting officer. Are you aware of what factors might contribute to this, to any inconsistencies?
Well, there should be consistency. I think sometimes there may be a question of the pricing information, and I know you've mentioned that previously.
Yeah.
And so technical evaluation panels can receive pricing information, but what we don't do generally is provide the price at the same time they're doing the initial technical review, because we don't want that. We want a basic technical review as opposed to the saying, this one's really inexpensive, so it's fine. So they can receive, and so I think where you probably see the difference is in the pricing information that is provided to the panel and when.
Okay. And did you say there's typically a subject matter expert or representative from the client agency included on the panel?
Always. I mean,
Always.
OCP staff are not members of the technical evaluation panel.
Okay. And then you just touched on this with the pricing, but they do receive pricing details, but not all of the details, right?
They may receive some, like the total price, they may receive certain aspects. In some cases, we may need to have the experts in the agency explain the pricing and the impact of it to us, because there may be considerations that they are aware of.
Sorry, I haven't been turning to you, but if you had anything to add on any of that, that's.
Ms. Heyman did a good job of summarizing
Okay.
what we think the TEP panel does. As far as pricing, we're in agreement. It's generally not relevant to the job that the TEP is doing. They're there as subject matter experts on the technical side to provide advice to the contracting officer when they make their ultimate decision. We don't want the price to potentially influence, even unconsciously influence the TEP team when they're making their recommendations. And that could happen if they're aware of the price. So the less they know about it, we tend to think at OHG, we tend to think it's better at OHG for those reasons.
Okay. And are there established criteria guiding when a contracting officer can deviate from a panel's recommendation, or is this largely at the discretion of the contracting officer?
I would take a different approach to that starting out that it is the contracting officer that is the one who ultimately makes the award.
Okay.
They're the one who has the warrant. They're the one with the training on how to make award. They understand how the criteria works, how the procurement as a whole is supposed to function. The TEP members are clearly helpful. They are the subject matter experts, and they're going to usually provide excellent technical advice. They will provide their own scoring. But at the end of the day, it is the CO who has the warrant, who's making the award, who needs to understand the basis for the award. So I guess I forgot the basis of the question, but ultimately it is the CO who is making the award. The TEP's there more as an advisor, as an assistant.
And I'm going to agree with that. And I'm also going to just give examples of things that the contracting officer might review. Because again, the contracting officers are not necessarily the subject matter experts in the content of the procurement. However, the contracting officers are there to be the procurement experts. And so they will look at what the TEP does. And when they do look at what the TEP does, they may notice things like the TEP missed something. They didn't rate part of one of the evaluation factors, or they misunderstood the factor, or they rated it inconsistent with the scoring, because we rate on a 0 to 5 scale and they mean specific things. So if something's missing from a proposal, they should get a lower score. But sometimes the CO, the contracting officer, may notice that the panel gave them a higher score than was consistent with the remarks that they provided. So those are generally the kinds of things that the contracting officer is doing, as opposed to saying, I think this specific system is not the best one. It's, did they follow the procurement process?
Sure, and if I can just add, when the CO and the TEP do disagree, which is not often, it does happen sometimes, we require, and I know Nancy fully supports, that the CO explain in the independent evaluation why they're disagreeing with the TEP. It's not done just, they state a reason why in their explanation why there's a disagreement, and there has to be a rational basis before we're willing to approve it at OHE. So there is thought behind the contract officer's decision when they do disagree with the TEP.
Great. That was going to be my next question. So thank you for that. All right. Now, in a different vein, council hears from client agencies pretty often that they're completely in the dark on critical procurements that they're counting on moving forward. Why do you think that would be?
Well, I think it depends on what they're in the dark about. One part is that if they want to know the specifics of the evaluation process, such as how many respondents there were, how many proposals we got, what anything about them, that is not information that we are able to provide under our procurement regulations. However, sometimes we also find that we communicate, let's say, to one person in the agency, and they may not have shared that information with all the affected people in the agency. But I think in terms of overall where we are in the procurement process, that's what we're looking to at least give the agencies more information on that. Not necessarily the details of the nitty-gritty of the evaluation process, but what's the timeline for your solicitation? Where are you? When's award projected to be made? And this takes us in a little different direction than the evaluation, but we have worked with our agencies to develop a system we call PALT, Procurement Administrative Lead Time. It's an interim system until we can get our past modernization moved to the Oracle system. And we divided procurement into 5 phases. And so we have in it, each phase has a projected date for completion, and it allows the agencies to go in and see that information. They can track it by requisition that they have submitted. And so, excuse me, we are trying to give the agencies more information in that regard.
Okay, that's helpful. I was going to ask you if you think, do you think the law should be changed for you to be able to share more after the fact about the details of these contracts?
Well, we can share after the fact. The problem is we think it should remain confidential during the process, because we don't want someone to realize they're the only one who responded. It doesn't put us in the best negotiating position. Sure. So that's why.
And it's like information management at that point?
Yes, yes.
Okay. Anything you'd like to add?
Yeah, other than proprietary information, I think pretty much everything can be shared after the fact. We should be confident with our decisions, and we should feel confident sharing even independent assessments, I think, at the end of the day, with the public or agency heads. I think Ms. Hayman hit it on the head, but during the procurement, you really, I understand some agencies may feel shut out. That's kind of on purpose, so they can't in any way potentially influence the TEP team or the CO during their evaluation.
Thank you. All right. I guess we're going back to the supply schedule again. Currently, how often does OCP review and update the supply schedule?
There is no schedule for reviewing and updating at the moment, but we are starting a process where we are examining various aspects of the supply schedule program.
When was the last time you did?
Well, again, we don't have any formal process for it, so I can't really provide a date on that.
Does OCP have any recommended changes to increase CB and contractor participation?
I think there's a lot of participants in the supply schedule program now, but what the data is that I'm looking at now is really the usage of the particular schedules. For example, I mentioned that there's 17 categories. I'm looking at the usage because it may not be beneficial to either OCP or the contractors to have a schedule that has extremely low usage. One, because it creates expectations on the part of people that they're going to get more business than they do. And then in the other categories where there's more business, I am looking at the distribution of orders to make sure that people are engaging in the order process that they should be following. For example, the supply schedules require that you go to 3 vendors and get quotes. And so I'm looking at the distribution of orders to see what it tells me. Again, getting a supply schedule is never a guarantee that you're going to get any specific business, but we want to make sure that we are not narrowing the opportunities for people to compete for those orders.
Okay, and I'll say, let me ask one more question, and I'll turn to OAG, but what adjustments to supply schedule could help make the process more efficient for agencies? Either of you could answer that.
I don't really have much to add on supply schedules. That's
Okay.
really more OCP's purview.
Okay.
Oops. Okay, what I am intending to do, and probably the timing of this depends on the modernization of the procurement system
Yeah.
and the new system, but we will make sure that all the contracts are in the system. Right now, they're done basically as separate documents. They're not generated in the system. And then I want it so that agencies within certain limits of dollar value or types of contracts can go in and place some of their own orders. They would probably use their P card to pay for them, but the idea is to make it more of a marketplace experience where we can.
Oh, very interesting. I guess I think I assumed it was more like that, so that's
not in terms of agencies right now can't go in and place their own orders. And so that's the first thing I think that would make it more like a marketplace. And then the second is the information, because the contracts aren't generated in the system now, the information is not always easy to find.
Makes sense. And so what aspect of the PASS overhaul needs to come together in order for
this would be in the sourcing and contracting module. So that would be the phase 2, which we're starting now, but the actual implementation of phase 2 will not occur because we're still in phase 1. Phase 2 would be completed by October 1, 2027, but to the extent that we can make changes that become effective, we can do some workarounds now, and then we can also build the system to match it.
Could we see the supply schedule usage data?
Sure. I'm in the process of the team is still gathering it, but I expect to be briefed on it within the next month or so. We'd be happy to share it.
Thank you. All right. Now, regarding the proposal to establish a consolidated procurement portal, how does this language align with OCP's current modernization efforts, including PASS and the transparency portal?
Okay, so this is one where I know our Chief Information Officer would love to have the chance to talk to your staff about the details. However, for us, we totally support transparency portals. What the concern is that as we're moving to the Oracle system, that we don't want to be particularly tied to a lot of details that we do not know whether they would be compatible with the Oracle system. Our Chief Information Officer is a huge fan of portals. But for example, right now, I think the statute lists several categories of access licenses and talks about how things need to be done. And that right now would be restricting or constraining the flexibility to work with the Oracle system on how things could be done. Because some things may be combined in one portal, some things might be better in a separate portal. So that's why we want to have the legislation really have more of the goals that we're trying to accomplish as opposed to the specifics about how to accomplish them.
Is there a reason we need a separate portal for contractor payments?
Probably that would change once we're going to the Oracle system. It was needed when it was first established because the PASS is not the payment system at all. And so that was with CFO and became diffs. Right now in phase 1 of the modernization, we are looking, we call it improving the vendor experience. And it is the portal that is currently used for payments and invoicing will become just the CFO's portal. And so that's already, the end of phase 1 already accomplishes that task because it now just becomes the CFO's portal in diffs.
And what portals do you think should remain separate?
Well, I think there's a way you can do separate portals, but not necessarily have it totally the way it was done with the vendor payment portal versus PASS, because that was really two separate systems. I think there are ways that, excuse me, things can connect and through the use of APIs and other things that how you access the data. And I think that's something that would be configured as we're going forward.
Are you referring to DSLBD's payment portal?
No,
Okay. Any idea why that's with a different agency?
no.
Okay. Mr. Schildkraut, did you want to add anything about portals?
We lack expertise in portals. We have nothing to add on that.
Okay.
Oops, actually back to the DSLBD portal. I don't know what it shows, so I don't know if some of their issue is to show payments to subcontractors as well. I don't know if that reflects it.
Okay. I don't either, so. Okay. Under district law, what happens when the district pays a prime contractor, but the prime fails to pay its subcontractors?
Well, for the subcontractor, it's unfortunate. Subcontractor has an action against the prime contractor in district court. I'm often asked, why can't OIG get more involved in the prime contractor and the subcontractor dispute? The reason is because we have no privity of contract with the subcontractor. We have no written agreement that binds us to any terms of or any kind of an agreement. In fact, we actually don't necessarily want to get involved in a prime subcontractor dispute because we don't want a prime to come back and say we are interfering with their contract with the sub and potentially face some kind of litigation from the prime.
So do we have any legal role in resolving disputes between primes and subs?
No.
Okay. Has there ever been an instance where the district has gotten involved in this type of situation?
I'm not aware of one.
From OZP's perspective, I mean, how do you track whether a prime contractor pays the subcontractors who are providing the actual service and how that impacts our contracts with them in the future?
We don't track payments to subcontractors, but I would say back to the role of the ombudsman, one of the areas that the ombudsman deals with is when subcontractors come in and raise issues. Now, we do have a clause in all our contracts that reflect the Quick Payment Act that requires that subcontractors be paid within 7 days. So I think that if a sub were to come to us, we can't make the payment to the sub or have anyone make the payment as OAG has indicated. But we can talk to the contractor about their compliance with contractual provisions. And that is a conversation and how we would have to tackle it with the prime contractor. And if there is a prime contractor who's not making payments and it's interfering with the performance of the work, because subcontractors after a while stop working if they're not getting paid. And so we would then have to take action against the prime contractor because they have failed to meet the requirement to pay subcontractors within the stated time and to continue to have performance.
Okay, so the subs are ultimately covered under quick pay, as long as that's in the contractual agreement. Is there
It's
also?
a statute.
I was gonna, that's what I was
So
gonna say.
it
Okay,
doesn't
so-
even have to be in the contract.
So if a prime is not paying out a sub, and following the statute under quick pay, does OAG then have the ability to get involved?
We have not, and I suspect we do not have that ability because we have not done that. I'm not aware of the history of us doing that. Again, I think their remedy is through district court and
Okay.
doing their own action.
I mean, I think quick pay helped a lot with that.
It did,
Yeah.
because it creates the specific time frame with which payments may be made. And we have used payments to subcontractors in a couple of cases where we have terminated a contract because that failure to pay the subs carried over into their inability to perform the contract.
Okay, that is kind of what I was getting at there. Okay, you answered it better than I asked it, so thank you. All right, so you can, that can be something you consider for a future contract.
Yes, and it still doesn't get the subcontractors paid, but at least.
It means we're
we
not
have a-
doing business with people that don't pay their
Right,
subs.
right.
Yeah, and I think that would go to their responsibility determination, whether or not they
Yes.
have a record that indicates they're trustworthy and have the ability to actually perform as whatever the terms are included in the contract.
Okay. Provisions in the mayor's bill. So the delegation of authority by the CPO. The mayor's bill includes language explicitly authorizing the chief procurement officer to delegate certain authorities. What's the reason for this change?
The reason is, I think, just it's almost a technical correction of the statute because there's parts of the law, the PPRA, that talk about the CPO needs to do something. There's parts that talk about the CPO or designee can do something, but the CPO cannot personally do all the things in the law that are stated. And so we already delegate functions to different people within the agency, but this just eliminates the need for any confusion about whether it really means something to say or designee or not. And this particular issue came up especially for determinations to proceed while a protest is pending. At one point, the Contract Appeals Board indicated that it had to be signed only by the CPO because it didn't say or designee. But that's a little impractical if the CPO is ill or otherwise unavailable on vacation. And so this is just to make sure that it's clear the CPO can delegate any of these authorities.
Okay, I think you gave, those were some good examples. And Mr. Schildkraut, did you have any thoughts on that?
No additional thoughts.
Okay. The bill would allow the CPO to use any legally permissible source selection method to acquire goods and services. Why do you think this flexibility is necessary?
I think this flexibility is necessary so that we can adapt to changing market conditions and how people provide services. And I think when the earlier witness talking about AI procurement, I think that is exactly why we're looking for this kind of provision, because the AI is changing so quickly, and the way people procure AI is probably not going to stay comfortably within the traditional procurement methods. And so to have this flexibility, instead of having to go back and get the law changed to add another procurement method, would allow us to proceed at pace with some of the changes in the world, especially for the technology. We already have a handbook that or a procurement guidebook that we've done, and I anticipate that it's going to be out of date very soon just because of the way people are looking at procuring AI. We do look at the state of California is more of a leader in that area. There's also something, I think it's called the OpenGov AI Coalition, which is out of San Jose. They are an excellent source of materials. So we're always looking to them to see what new ideas they're bringing on how to do AI. Because one of the things lately is that people want to do what it called proof of concept. Don't award the contract necessarily, but do a process where you get somebody to give you their concept. Then you give a certain number of people a certain period of time to develop it and show whether, and then the agency can decide whether it works or not. So those kinds of things are behind that provision.
Thank you. And from OAG's perspective, what risks could arise from granting such broad discretion rather than specifying allowable exceptions?
I can certainly understand why Ms. Haven OCP wants to have more flexibility in their procurement process. It'll be more efficient. However, going back to what my testimony, we need to always balance that efficiency, with transparency and fairness. We already have many source selection methods: RFP, IFB, sole source, emergencies. There's a whole list, and there are rules that support each of these methods. And when we start receiving proposals and we go through the process, we kind of know potential problems that we might face once the award is about to be made or once solicitation is put on the street. If we're going to use new methods that don't really necessarily have rules or codified in any way, it opens us up for uncertainty. Basically, the vendors are only going to be able to follow what's in the solicitation. They won't have any other real guidance about what is going to be, how the outcome what they need to prepare or propose and include in their proposals. So it just leads to uncertainty and a lack of guardrails. Those are some of our concerns, but we certainly understand why they might want to do that for efficiency reasons.
And I guess I would like to add to that, we certainly would expect any process that engages with the public to have regulations as is required under things like the Administrative Procedure Act. So while it may be a new method, it doesn't mean that it's the Wild West either. We would have to do the regulations to set forth the parameters.
So, Director, the FIS references a requirement for written justification. Who would this justification be submitted to and what oversight would apply?
The Chief Procurement Officer would do the justification, and the oversight would be the oversight that's currently available through the auditors, through the IG, through the council, whoever normally does review of anything that we do.
Okay. Did you have thoughts on that?
No real thoughts other than what I've already stated.
Cool. All right. The bill proposes changes to council approval beyond what's in the other bill, including for locally funded construction and transportation contracts and capitally funded vehicle purchases. Do you have any concerns about how this might impact public oversight?
I think oversight probably would change from the council perspective because I know that oftentimes council is looking at these as on the individual contract basis. So the plan would have to include enough information, and truthfully, we would have to probably have discussions with the council about what kind of information the council would want to see in the annual plan. But it would eliminate the need for individual contracts to come to the council. But there's nothing to say that the council can't do more detailed oversight or engagement if there's certain contracts that catch their attention. They can certainly do oversight at any point to see where any agency is in terms of the progressions towards awarding that contract, how the performance is going. But it would change the nature of oversight some, because I'm not sure that review of a specific contract or option is always the best time to do oversight anyway, because people are ready in the option exercise, you're ready to award it. There's very little time to do any alternative. With the award of a new contract, you don't have to award it, but sometimes the new contract continues essential services. So again, there's that, it's not necessarily the best time to do oversight of a program.
Mr. Shellcroft?
It's my understanding that this is potentially very similar to the DC supply schedule, creating new plans of contract for certain types of contracts. If that's the case, we would have the same kind of concerns we do with DC supply schedule, the lack of there would be less oversight, as you've mentioned. We wouldn't have our normal reviews on certain types of contracts. Those would be our concerns.
Okay. And Director Hateman, are you certain this would not run into conflict with requirements set out in the Home Rule Act?
I think that, like I said, I think the Home Rule Act does allow for the council to set the criteria for contract review, and the Home Rule Act doesn't specifically define what part of the contract the council needs to see. So I am comfortable with the council being able to set plans.
I understand the ability to submit contracts during council recess would make your lives much easier. Contracts not being submitted during recess is a result of council rules, not a provision of law. I don't want to make any changes our central office can't logistically handle. Have you sat down with the council secretary to discuss how they could make this work?
No, I haven't, and you are correct that it would, right now it is in the council rules. But I would imagine the council would have to determine what changes and new procedures or adjustments would have to be made. And I'm happy to have those conversations.
Okay. The bill also revises who may provide legal sufficiency certifications to the council. Can you say more about this?
Yeah, this has come up in discussions within the executive. There are times when we have a need to just have some packages move through the system. And when I say that, not to skimp on legal review, but maybe there's certain basic packages that an agency council is able to do, and they do take away the time from OAG. They also create a little bit of a bottleneck especially when we're before recess, overwhelming OAG with a number of packages. And the thing to remember about OAG is they're not just reviewing our contracts, they're reviewing CFSA and DCPS and DGS as well, maybe others that I'm not aware of. So they do get a lot of workload. And so I think there's certain actions that an agency council, if they're trained and familiar with procurement, are very able to handle. And then that would allow us to have the time to work with OAG on ones that may require more in-depth review.
Mr. Shellcroft?
This bill would add no additional new authority to what's already in the PPRA. We have unique knowledge of many legal issues that could cause potential problems down the road with procurements. It's our position that nothing should change on that area of the legislation.
Okay. And would certain contracts still be required to go through OAG for certification in this?
In the bill as proposed by the mayor, it doesn't designate those or a specific category.
The current PPRA just requires legal review. It does not differentiate between agency council and OAG. And the way it's currently is working just fine. No changes are needed.
Okay. The bill removes the requirement to issue a determination and findings prior to conducting a competitive sealed proposal. What practical effect would this have on the procurement process?
It would remove people having to spend time to do what I consider to be a useless document. I think it's really a holdover from the old days. A while ago in procurement, when IFBs were viewed as the competitive procurement and RFPs were viewed more as a special situation. But now I think RFPs are established in our law and in procurement. knowledge in general as being an appropriate competitive method. And so this document is just a totally pro forma one where they say we can't award based on lowest price. We will consider technical factors such as past performance, technical proposal, and price as well. So it would just eliminate the need to do a document that really doesn't add value.
Absolutely. Yeah, that portion of the bill is from a different time. RFPs are commonly done now, just as much as IFBs. There's no need. It's the DNF is, as Nancy put, pretty much a waste of time.
Thank you. Okay. How do your proposed changes to TEPS complement or differ from the changes proposed in my bill? Could they be merged?
I think the bills could be merged, but not 100%. There are some things that we testified earlier are problematic for us, but I think there is ability for the bills to merge. And I think I would like to point out there is one part of the bill that talks about the contracting officer being able to just adopt the recommendations of the TEP and the scoring. And right now, under current law, the requirement is that the contracting officer has to write out a whole different independent assessment. The contracting officer can't repeat the way that the TEP has said it. And so it creates a lot of time. So any merging, I would really urge, include something that allows the contracting officer to adopt either fully or in part the comments of the TEP. And then I did raise some issues in my testimony about the 14, I think I raised about the 14-day review period and the contract review panel. Those seem like they create more bottlenecks than they help. But I think there are parts of this that could easily be merged together into a provision that works for both of us.
We have some concerns regarding the TEP simply adopting the contracting officer simply adopting the TEP's evaluation. There are times, it's important that the CO understand the basis for their award. There are times during a bid protest where the contract officer may be called to testify and explain the basis for his or her award. I suppose if they adopt it, they can become familiar enough where they understand the basis for the award, but it's very important that they have their own independent assessment, understanding why they've made a decision in case they are questioned by an unsuccessful offerer about why an award was not made to them. Simply adopting without having a full understanding of the basis for the award could be problematic again in litigation purposes.
I would agree with that, but I'm not talking about mindless adopting of the things. It's just sometimes when we have legal reviews of the comments, if the CO seems to be, I'll say, repeating too much of what the panel has said, they are told they have to use different words. So I think I agree. The CO owns the decision and they have to be able to explain. I think that we're talking about something where it's part of a reasoned analysis of the TEP.
So something like they can incorporate the TEPS assessment, but it can't be all there is.
No, I would imagine that this would work for certain factors more than others. They might have one factor where they really think the panel was spot on and hit it. They might have another factor where they think the panel missed something, in which case they would not be able to adopt it completely. But there may still be parts of what the panel said that they think are appropriate to adopt.
Sure. When we review the final package, we want to make sure the CO has a full understanding of the basis for their award. And however they want to go about explaining that, it's fine with us.
Okay. Can you say a bit more about the additional protections for proprietary information of offerers? What's the issue you're intending to resolve with the bill?
Well, I think one of the issues is workload management of FOIA requests because we often find that we get numerous requests from companies that have submitted a proposal, but they did not receive award. So they want to see the proposal, obviously of the winning person, which would be available with the redactions because they did receive the award, but sometimes they want to see what the proposals were of any of their competitors to just see what they can glean about their competitors' technical approach or marketing strategy. And there's not really a benefit to the procurement for us to be providing all of this information in response to a FOIA request. Now, if people need the information as part of a protest, that is not covered by this, and they would, protest rules would govern who gets to see what in a protest. So this is just purely on the FOIA part, and what we're proposing is really mirroring what the federal government has adopted a while ago.
Yeah, I saw this question and I wasn't quite sure what it was getting at, what part of the bill, but now I understand what Nancy was saying, and that makes a lot of sense. I do believe that that all vendors are required, I don't think they actually do it, but I believe they're supposed to submit a redacted proposal with their proposals. I think we see that about 1% of the time.
Well, we may get redacted proposals, but many times they just say everything is proprietary,
Right.
including the name of
Say
the
that.
company.
We have done that.
So then we have to do a what is a reverse FOIA request, go back to them and say,
Yes.
okay, you can't say that everything is proprietary and confidential. So now you have to come back and tell us what really is proprietary and confidential. So we're cutting out a lot of that back and forth as well.
That does make sense.
Has OCP engaged with CBEs to assess how this change might affect them?
No.
How administratively burdensome? Well, you've kind of answered that. I'm going to skip that. You've weighed in on it. Okay. So the bill raises the threshold for non-competitive procurements to $25,000. What types of purchases typically fall within this range?
I think that typically what falls in that are operational supplies, goods of various sorts, small renovation projects, and some technology. Let's say if you're buying a couple laptops, and people do buy laptops randomly or software licenses, those kinds of things would be within the $25,000 range.
So like a bulk order of laptops.
A bulk order of laptops, it might be $100,000 more.
Yeah.
But if an agency all of a sudden has some new staffer and they need one more laptop, it would fall within that range. If they need 3 more laptops, probably they could still be under 25,000.
Remind me what the threshold is right now.
10,000.
So you buy a laptop that's worth more than $10,000?
No, not individually,
Oh.
but some they buy maybe more than one at a time.
Got
But
it.
if you're buying 50 laptops for a refresh, it's
Got
not
it.
going to fall
I
within this.
thought of bulk is maybe smaller than.
I know.
Okay. Okay.
Yeah.
All right. Yes, we have smaller offices around here than you're normally dealing with. Okay. Can you say more about the rationale to allow COs to establish retainage rates for construction contracts with progress payments?
Okay, right now, the statute does set the retainage rate at 10%. However, what the industry seems to have been going to and what other jurisdictions have been about maybe you don't need to hold retainage if the contractor is performing well. And so in construction, most payments are based on a progress payment. So for example, in construction, I think there's a 35% progress, and then there's other percentages of progress that they get payments based on. So if they are successfully performing in accordance with the contract, at some point the contracting officer can determine they do not need to withhold the 10% anymore, and that for payments going forward, they can not withhold it, and they can actually release the retainage that they've already withheld. So it would not probably be something at the beginning of a contract that you would say, we're just not going to do retainage. But once you've established and hit certain progress, the contracting officer can make that determination.
Any thoughts on that?
Yeah, this really seems more like a policy issue that it's really up to OCP and what kind of risks they're willing to based on their procurements. Certainly no legal objections.
All right, so just to clarify, does this mean we'd be paying for an entire project in advance, even if they've only made partial progress?
No, it wouldn't be in advance. They'd only be paid on what they've performed.
Okay. And can you clarify how retainage rates interact with progress payments?
So when when a contractor reaches that milestone that they can submit their invoice for the progress payment, if the retainage is being held, they would just withhold, the whole invoice might be approved, but 10% of it would be withheld and not actually paid out at that time to the contractor.
Mm-hmm. Okay. And how do you compare that to the pay for performance we were discussing earlier?
I think there are some similarities, but I think of pay for performance probably in a more progressive manner than retainage, because retainage is a much more traditional concept that's been applied to government construction contracts for ages.
Fair enough. All right. Do either of you foresee any potential issues arising as a result of this change?
I don't see any.
Not aware of any.
Okay. All right. Now, getting into suspension and debarment decisions regarding the changes, what's the intent of limiting CAB's review to the administrative record?
But we didn't propose the legislation, so.
Oh, okay. I didn't know. I thought maybe your testimony had covered this issue a little bit. The idea is that when there is what this really gets to, I think what OAG was talking about, the standard for review of that the CAB would apply for some of these things as well. And so.
I mean, I can address substantive, but regarding the cab, I mean, I think we're certainly open to hearing their thoughts on this. Is that what you asked?
Well, I'm curious about the intent of limiting CAB's review to the administrative
Limiting
record.
CAB review to
and- Yeah.
Sorry, I misunderstood your question.
No, that's okay.
Unlike a source selection decision that's made by a contracting officer, the debarment and suspension decisions are made by Nancy at the CPO agency level. So there's already a strong administrative record.
Mm-hmm.
And we really don't need to collect the record for a second time. That's already been done.
Got
So
it.
it really should, the CABS portion should be limited to the legal review, whether or not it passes muster of the law, and whether or not CPO's decision was arbitrary and capricious. So it's just more, we don't need to, it doesn't need to be duplicative. We had that recently in one of our procurements, and it slowed things down quite a bit.
And I would say there are some things that already the CAB has a standard of looking at, is it arbitrary and capricious
Absolutely.
versus having a full hearing anew. So this wouldn't be an inconsistent concept.
It would be very consistent, actually, with
Yeah.
all the other standards.
Great. Is there anything the CAB currently considers when making a determination that would no longer be available under this proposed change?
Other than doing their own fact finding, that would be the one thing they would no longer be able to do. They would have available the full record that CPO had in front of her.
Yeah, in debarment proceedings, we develop what we call the administrative record, and that starts with the determination and findings that we do in OCP to initiate the process. It would include the notice that went to the affected contractor. They have an opportunity to submit any information that they think is relevant. We have what we call an informal hearing, and they can come in, and if they choose to, they can come in and present to the chief procurement officer, and they can then follow up with additional information if they want. So that really comprises the administrative record. Plus, there's a full written decision on each department action.
Okay, that's helpful. Thank you. The bill establishes a 3-year timeframe for contractors to bring claims. Is that right?
That is correct.
Okay, well, was there previously any defined time limit?
No, and I think that that was part of the concern. And Rob, do you want to?
Yeah, we thought that there needed to be a time limit of some kind. At some point, the district needs to know that it's not going to be financially responsible regarding a contract. It can't be open-ended. Eventually, personnel who might even be knowledgeable about a potential claim might leave the district government. Records might disappear. We wouldn't be necessarily be able to defend a claim that is filed 10 years after a contract was completed. Just at some point, there needs to be a stop dead date to allow the district to move on from that procurement. And 3 years is common. I think it's similar. I think the feds might be, I'm not sure the feds are, they might be 5, but they might be 3 also. Do you remember by any chance?
We can look.
It's 3 is reasonable, we believe.
Okay. How frequently are claims submitted beyond 3 years?
It happens. Not all claims come directly to OAG, some come to independent agencies, but we have seen that claims are submitted after 3 years. And it is more difficult to defend for the reasons I've just stated. The personnel who are involved in the contract administration are no longer with the government. Documents have been destroyed.
And was there any feedback collected from CBEs and stakeholders on this proposal?
We did not collect any.
Okay. The next section of the bill adjusts the timeline for appealing denied claims to the Contract Appeals Board. Can you clarify how this differs from current practice?
I have to admit, I'm not completely familiar with this portion of the legislation.
Okay, so I'll
You please.
jump in, and then Rob, if
Okay.
you have anything to
Sure.
add.
Mhm.
Right now, excuse me, the time for appealing denied claims is based on the receipt of when the claim has been, when the receipt of the decision from the contracting officer starts the clock. However, there is another category of claims that are treated as denied, but there has been no decision of the contracting officer. And those are called deemed denials. So I think it's after 120 days in our current law, if the contracting officer has not issued a decision, it's considered deemed denied. And it authorizes the contractor to go to the CAB for an appeal. However, what is still the gap in the law is if the contracting officer has not issued the decision on the claim, but the contractor does not go to file the appeal, they have no timeline. So they could wait a year, or, I mean, I hope the contracting officers aren't waiting a year, but there's no set trigger of the time. And so I've checked, and this is basically consistent with federal practice and other practices about having not only the timeline for when there's an actual decision, but when there's a deemed denial as well.
Okay.
Nothing to add, that makes sense.
And was CAB consulted on this one?
No.
Okay. The bill also eliminates CAB's role in reviewing determinations of urgent and compelling circumstances. What's the rationale for this change?
So for this change, there's 2 parts of it. One is that in looking at what other jurisdictions usually do as a general practice, it's the contracting officer or the chief procurement officer, not the contracting officer, the chief procurement officer who makes the decision on whether there are urgent and compelling circumstances. In the case of our situation, the CPO can do a determination to proceed. Then it goes to the CAB, but the other parties then can engage in litigation back and forth about whether this should be granted by the CAB. And I think, Rob, you might be able to talk a little bit more about how much that litigation is involved in.
Sure. Yeah. For early in the process, currently, a vendor could ask the board to stop all performance if they file their protest within, I believe, 10 days of knowing the basis for their protest. And if the board believes there is a reasonable basis to stop it because the vendor could be harmed if performance continued, they will stop performance. So we will litigate the protest and performance will be stopped unless OCP believes it's important enough that stay should be removed and to move forward with the procurement while the protest is occurring. This would pretty much change who is responsible for which part. It would be assumed that there would be a stay under the legislation. We have some concerns about that, more based on due process issues. Once the stay is in place and performance of a contract has started, it's hard to remove that contractor from actually performing that contract when they've gotten to a certain period in that contract. And if the vendor doesn't have a chance to challenge that award early on, and they ultimately do prevail in a protest, even if they end up winning that protest, the remedy will unlikely be performance of the contract. The reason I've just stated, because performance would have gone on so far that a large chunk of that contract would have already been performed, or it wouldn't make financial sense to go back and start all over again. So in some ways, that vendor lacks the ability to really have the chance to get that, ultimately perform the award. They may get a remedy at the end of the day, but if they can't stop that vendor from performing, their ability to, as I said, have a remedy that includes performance of the contract is limited.
I would add from the operational perspective, as CPO, whenever it comes to me for a decision on whether to proceed or not, regardless of whether there's the ability to go to the CAB or not, I look at what the protest is and what we think the chances are of prevailing on the protest before we make any decision. Because there is no benefit to us to deciding to proceed and then find out when the CAB issues the decision on the protest that we have lost, because now we have to pay termination for convenience expenses costs to the party that got the contract for that period of time. And almost anything that is a system, automated system, I would not even approve a DNF because the cost of starting up with a new vendor and then ending it are just too much to even go down that path. So it is something that this authority has to be exercised in a reasonable, common sense manner based on the circumstances.
And how are we currently define urgent and compelling circumstances?
It's a high bar. I believe it's health, safety, and welfare of the district is the legal standard used by the CAB.
I usually tell our contracting officers it's almost the same standard as emergency contracts.
Similar, yeah.
Yeah, it echoes that a lot.
Great.
And what's the reasoning behind the removal of the supported by substantial evidence standard?
That comes down to a requirement that the CAB had put in place a while ago, that there needed to be documentation, a high level of documentation from the program agency or the agency director on what there's questions about what constitutes substantial evidence, and we feel that the bar was kind of set rather high on what constitutes substantial evidence, because that's even more than just regular evidence.
This section eliminates CAB's review of determinations to proceed. What's the justification for removing that oversight?
I think I started to hint at some of that earlier, where just really you get into that litigation process where you're going back and forth and the time and expense of debating that issue.
We do see it as a safeguard for some of the vendors when they do protest to make sure that there is a true compelling need to move forward. The cab is a non-bias in that area.
You see the
need to continue that,
the review of determinations to
Yeah.
proceed as an important safeguard.
we do.
So you would lead that.
Mhm.
Finally, the bill authorizes COs to designate when subcontracting plans are due and negotiate the terms of subcontracting plans with vendors. Can you talk a bit about how these proposed changes would improve the vendor experience, especially for CBEs and SBEs?
I think this change would improve every vendor's potential experience, and including CBEs and non-CBEs. Since the conduit decision changed our practice, we have had several solicitations in which we have not been able to make an award because of technicalities in the subcontracting plan, and we've had to resolicit that procurement. So what does that mean? That creates delay in an agency getting the goods or services. And that also has an impact on competition because a vendor who responded once may not be interested in responding again for the same services. And so what this would do would allow, the DSLPD law has 4 criteria that have to be in the subcontracting plan. What this would allow vendors to do is to go in, and if they make a mistake, to fix it. An example, when we were doing the managed care solicitations a while ago, some of the vendors had incorrect CBE numbers listed. So they had a problem, they were not compliant. And so it would just allow someone to come in and fix their plan, as opposed to having to say, oh, we have to throw you out of this multi-million-dollar procurement because you didn't have the current CBE number listed. And then there became a question of what number did they need listed, because as they get recertified, the number changes. They don't carry the same number with them throughout their period of being certified. So that's just an example of something. Maybe they've made a mistake in calculations. Let's say it's supposed to be 35% subcontracting amount, and the vendor has come up with 34.1%. Technically, their plan is not compliant. And so this would allow us to be able to continue with procurements and with vendors without having to resolicit.
Yeah, not being able to negotiate subcontracting plans have led to some nonsensical results. You would be surprised at how much litigation we've had to deal with regarding vendors being removed for, as Nancy put it, incorrect CBE numbers that could easily be fixed. Decimal points being slightly off. Areas that could easily be fixed during the best and final offer, keep them in the competition, and ultimately, if that offer ended up being the best value, we can make an award to them. We've had to remove potential vendors that could be the best value several times from awards, and it's cost the district great vendors at lower prices. It's really no need to not be able to negotiate subcontracting plans during the BAFOs.
Anything else you'd like to add, either of you?
I think we've covered a lot. I don't have anything additional.
No, I hope we were helpful.
Yeah, thank you so much. Appreciate you both. This concludes today's public hearing. If you plan on submitting written testimony for the record, please do so by going to the council hearing management system. The record will close on Wednesday, June 24th at 5:30 p.m. The time is 12:21 p.m. and this hearing is adjourned.